Obviously, the goal of today is to explain a little better about electronic communication privacy and to talk about where changes need to be made, if at all, and some of the efforts that are underway. We really couldn't have two better people to talk about this issue, in my opinion. So Professor Susan Freewald is with University of San Francisco School of Law. She is, many of you will appreciate the fact that she started off in software development, I believe, and so she understands technology. Jonathan's nodding his head. But also is a very widely respected scholar of the application of the Fourth Amendment and of U.S. statutory law to the electronic space. In addition, we have Kevin Bankston, who a name many of you will recognize as being a senior staff attorney at the Electronic Frontier Foundation. And he too has been right at the forefront of this issue, litigating some of the most prominent cases in the space and helping to coordinate the effort of digital due process.
First, I'm going to talk about a very pertinent example in this space. Then Susan's going to take us on a magical mystery tour through the history of statutory and constitutional law in this area, with me accompanying on the whiteboard. And then we'll discreetly address two big topics in this area. First, Fourth Amendment and statutory protections for content you store online, and Fourth Amendment and statutory protections for location information, such as that collected by your phone company about your cell phone. Warrants, and when are they needed? Does the government need a warrant to open your mail? Yes or no?
Yes.
Yes. Does the government need a probable cause warrant to wiretap your telephone calls? Yes. Yes. Do they need a warrant, barring an exception, to bust into your house and take your files from your file cabinet or to seize your computer? Yes. Does the government need a warrant to seize the entire contents of your Gmail account or not? Some confusion here, which is appropriate because there's confusion in the courts as well. And that's an issue that we have been working very hard on at the Electronic Frontier Foundation to establish that, yes, the government should have to get a probable cause search warrant to obtain the contents of your communications that you store with a third-party online service provider.
Held them up in Olmsted. But what's private and what's not? Something can't be private if you tell the world about it. But something can be private if you tell some people about it. For example, talking on the phone was something that the phone company was able to tap into. So the rule can't be that if anyone could possibly get access to this information, it's not private. And so the Supreme Court said, what are we going to do? And they came up with a rule to try to figure out when the Fourth Amendment applies and when it doesn't. And the rule is called the reasonable expectation of privacy test. And that's the rule in Katz, and that's the rule we still use today. And that's written on the handsheet. It requires a handout that a person exhibit an actual expectation of privacy and the expectation be one that society is prepared to recognize as reasonable. So if it turns out that the police are intruding on a reasonable expectation of privacy, Fourth Amendment applies, warrant requirement applies. If not, it's up to Congress to regulate the investigative practice, and they can impose whatever minimal restrictions or requirements they want. And when we get back to the ECPA statute, we'll see that for a lot of things, Congress has required next to no procedural safeguards.
Saying, well, actually, this isn't ripe anymore because the government has already gotten your email. It's already indicted you. There's no indication they're going to do it again. So the issue's not ripe, and we're vacating this decision. Very unfortunate.
There's not a real controversy, they said.
Yeah, not justiciable. However, we got a second bite at the apple when, after his indictment and trial, Mr. Warshak was convicted on those many varieties of fraud, and he appealed. And one of the bases of his appeal was that the email evidence should have been suppressed under the Fourth Amendment's exclusionary rule. And so we got a second chance to brief the Sixth Circuit on this issue. And just last month, the Sixth Circuit issued its opinion and once again agreed with us and found that the Fourth Amendment protected this email, citing to the same analogies as before, and specifically and quite effectively dealing with the government's argument about terms of service. The government said, hey, you know, these email providers, and pretty much every email provider, has a terms of service that tells you, well, you know, we may access your email, whether to provide spam filtering or virus filtering, or in Gmail's case, to serve you ads, or otherwise to provide or protect the service. And the court said that doesn't matter.
But, you know, there's been, you know, a lot of scholarship written about reasonable expectation of privacy and criticisms of it, including by me. And, you know, the reality is the Supreme Court has to come up with, there has to be some test. And if you look at all the alternatives, it's actually not a bad one. But it does require what I call a normative understanding or normative judgment about how we want to live. And it can't be just a positive discussion of sort of what people expect. It can't just reflect what people expect, because then you're right, as soon as people could just give up their privacy, even if they shouldn't, or the government could just, you know, announce, you no longer have privacy in X, we're gonna search X, we're planning to wiretap your calls without a warrant, and now do you have an expectation of privacy in it? So so there has to be a normative component.